strange things are going on. The defense is continuing to object and continuing to stand up to ask questions. In fact, they're asking the magistrate from time to time whether or not the evidence which the witness is giving, and these are calling of a name of a person present at the scene, describing what words are being used by people who are at the scene, and defense is getting up to object, or rather to ask the magistrate, can you tell us, magistrate, whether this material is contained in the written statement? Now, this is a trial, not a trial on statements, a trial on the evidence given in court. So at one stage, I had to point out to the court that this was a matter which really the magistrate should not be burdened with. The magistrate should not have to answer the defense lawyer every time, is that material which is contained in the witness's statement. They have an exact copy of the witness statement that I have, that the magistrate have. And so to stand up at every opportunity to ask the court, do you see that in the statement? That is a matter for cross-examination. And so we find that what is happening is continuous standing up unnecessarily is continuing to prolong this matter. We could have completed this witness already. We had 4 witnesses yesterday lined up. We had 4 separate witnesses today lined up. And we are still just in the evidence in chief of 1 witness. Now, you persons are sitting in court and you're seeing what is going on. A witness is attempting to say what she saw at the scene. A witness is attempting to say what she heard at the scene. Today, the witness attempted to call a name of a person and to say, well, that person was sitting next to one of the defendants. And in attempting to name the witness, the court ruled that you could not name the witness. And the witness's name was contained in the statement given to the police. I do not know if you're startled, but I am completely startled. This happens every day in our courts of law. Eyewitnesses to crime turn up in court every day, and they say who was running from the scene, who was standing at the scene, who was saying what. This happens every day. And we are now being told that the witness who is standing in the box cannot say from who she saw present, who was saying what, who was sitting with her. Now, this is startling to me. I have urged the court to reconsider some of these rulings. I will continue to urge the court because I expect that these matters will continue to arise in this trial. We have a number of substantive witnesses who will come to describe what I suppose many persons would have seen, but they will come and say what they have seen. The witness will have to give their evidence. And I wish that the witnesses will be allowed to give their evidence and to say what it is they have seen at the time that they were there. So that's where we are.
Mr. Ramdhani, the magistrate, in a sense, would have asked, for example, certain expressions like aggressive argument and the use of, instead using...
Our law reports are replete with evidence being written verbatim in the law reports, where witnesses stand up and say, I saw a quarrel between the 2 neighbors. They were behaving aggressively. This constantly is the evidence given in our courts of law. These are reported in our law reports. I now have a witness standing up and say 2 persons were behaving aggressively, and objections are taken. How can you give evidence of people behaving aggressively? Now, I don't know if you can walk down the road today and see someone quarreling with somebody and you can't describe that if you were to give a statement to the police or stand in a court of law. To me, that is completely strange. And this, what I say it's strange because I'm an attorney at law of 27 plus years of practice. And I have repeatedly seen, not only in courtrooms, but in law reports, the official law reports of the world, where witnesses are allowed to testify. I have seen people behave aggressively. This is where we are. I will continue to press the court that this evidence is relevant. This evidence should be admitted, and we should be allowed to present this case. This is where we are.
Are you concerned that because of the objections and the request for omission of certain words and terms, where the evidence may be watered down by the
I am
end of the
very
trial.
concerned that if a witness is not allowed to say who she saw present, when she has put that name in the witness in the statement given to the police, when this witness is not permitted to say, when she said witnesses are objecting, and to say what words are being used in objection, I'm concerned that this is not at all something that should happen. I'm very concerned about it. Thank you very much.
Thank you so much.